May I please, Your Lordship? Three NRL matters, Your Lordship, heard it last Tuesday, regarding, that is one regarding suspension, regarding another regarding inquiry report, my lord. Another, what I mean in one case, that is 8334/2022, my lord. Your Lordship has actually want to dispose of it, but we have said that it is a matter of regarding suspension, and they have reduced the substantial allowance. We made a prayer to keep the matter pending, and Your Lordship has fixed a date. But now we from the online, we come to it was disposed of.
You just give the mention of it, examine.
Yeah, I'm giving a mention over. Another matter, Your Lordship has want to set aside the order and remand them back. That order has not come up. I'm going to take matter. Another fix for appointment of it. Yeah.
Just give the mention of it.
Yes.
May I please, Lordship? My lord, a nurse while working in ICU, my lord, the unit, the male, my lord, the colleague has harassed her mentally and physically, my lord, for which she has put complaint against the higher authority. Now, that blue white, my lord, to protect that blue white, my lord, that the petitioner itself has been, my lord, now transferred to the another place, and the next day, my lord, now tomorrow is the next, my lord, the date where she has to join the new place of posting. It is totally case of nothing, my lord, administrative exigency. Lord, we have prayed this matter may can taken up 2 p.m., my lord. Some urgency is there, my lord.
Give the copies to the departmental council.
Yes, we have.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 1. Lordship, in this case, my senior has some difficulty as he is engaged in some other division bench matter.
You have taken consent?
Yes, Lordship, I have
I'm
taken-
for the petition.
Both sides are represented. On the prayer made by council for. You are appealing for whom?
I'm for the respondent.
Which respondent? There are several.
I'm for respondent number 7 to 14. 7 to 28.
There's something wrong. There's no set of council for 7 to 14. Please check up.
Acha.
7 to 14 is not my.
Yes, it's 19 to 28 then, Lordship.
19 to 28. Okay. Responding is 19 to 28. Responding of journal. There is a list after ensuing vacation.
Lordship, can it be taken up on 28th of June?
20 or
June.
20 June is not possible. It's just not possible. After vacation, you make a mention of it. Accommodation.
Obliged.
May it please your lordship. Lordship, I beg to mention a rate petition for admission, my lord. Matter was last listed on 9th of April, where the health department and private respondents have sought for 3 weeks' time. Matter not listed, my lord. Maybe Friday or next week as per lordship's convenience, my lord.
Due to the court master.
Next. Deeply obeyed.
I beg to mention item number 7, my lord. My lord, the conducting council, my lord, and Hawk is out of session, my lord. So, for adjourn for the day, my lord.
White has come for orders.
My lord, the record was called for, my lord. And rule was issued on last occasion.
Just wait, let us take up the matter. Because white has come for orders, we have to examine. We need the prayer when the matter is.
My lord, I have to leave, my lord.
But in orders, white is fixed.
For records, my
But
lord.
it will not come for orders.
We call for the records, my lord. We have sent letter. And our affidavit is ready, your lord, for swearing. Yes. Just sent letter to the court.
Okay. Both sides are represented on the prayer made by the non-counsel for the petitioner. Matter stands adjourned today, just after saying vacation, summer vacation.
Item number 6, my lord. Item number 6, I was required to file an affidavit in reply on the last occasion. Lordship had given me time till today. Now, my lord, it has been dispatched from Silchar but could not reach due to the intervening holidays. Lordship would like to take it up on Friday, my lord. I have sought the permission. of
Friday
my
is just
friend
not
here.
possible. News backup on the, it will go
On
after
Monday, my
vacation.
lord. On Monday, my lord.
It goes after vacation.
My lord,
Yeah,
that's a
Lordship,
transfer
please
matter. There is an
transfer
urgency on the
matter,
part of
Lordship.
the respondents.
Transformator stay is operating in their favor, Lordship, so an urgent hearing is required, Lordship. We have filed our affidavit.
The official notification says that the transfers would be effected on the 30th of June. any day before that, my lord, perhaps lordships.
The 21/6/2024.
36 is, my lord, the date on which they are going to effect. But on 30th of June, they are going to relieve the people.
21/6.
21. Obliged.
Okay.
Right, so six, to item number 5, my lord. The conducting council, Amar Khondogar is suffering from illness, my lord, and he asked me to take time for.
You have got instructions in item number 5.
Item 5.
Also, otherwise, compassionate appointment matter of 2012, the person is deceased, your lordship, but since the person is not, the council is not present. It comes to any day. Your lordship.
List of times when summer vacation is paid for by land council for the petitioner.
After version.
Item number 2 with 3 for admission.
Please, my lordship. May I pray for an adjournment for the time being, as my senior counsel is on the.
Time being. Okay, time being.
Item number 4.
Yeah, please. Lordship, I submit the order dated 20 of February 2023 passed by the office of the Assam Division. Whereby appointed the respondent number 4 for the post of head assistant. Annexer E page number 34, Lordship. So Lordship, page number 34, Lordship, what is the condition precedent itself in the order stated that, Lordship? The for appointment of the head assistant, Lordship, basic criteria is that, Lordship, the person concerned should render his services as supervisory assistant at least 10 years of services as per rule 6. And the seat appointment was made out in pursuance of the advertisement dated 25/5/2022. Lord.
Where is the advertisement?
Advertisement annexer C page number 23, Lord. Can you finish? That is the type copy, Your Lord. Advertisement itself says and condition precedent prescribed by the authority, Lordship. The candidate who have not completed at least 10 years of service as senior assistant, including supervisory assistant in different branches of the amalgamated established of the office of the deputy commissioner, Assam North, need to apply. That is a condition precedent itself advertisement says, Lordship. The said precedent has been violated by the authority itself, Lordship. The respondent number 4 who has been appointed for the post of senior assistant, Lordship, she did not render his services as supervisory assistant, Lordship. And Lordship, the petitioner number 1 is the senior most candidate as per the gradation list prepared itself by the authority, Lordship. Gradation list annexer A is page number 40, Your Lordship. Petitioner number 1 is the senior most candidate. And relevant portion is page number 42, Your Lordship. In serial number 8, that is clearly mentioned that your lordship, date
Just
of
a
entry
moment,
into
just a
services,
moment. Just-
10/7/1991, petitioner number 1, your lordship, page number 42. Annexer is.
Yes, who is appearing for the government?
We have filed the affidavit.
The stand is incorrect. The stand is incorrect.
GAT has not yet filed a report.
Respond number 3. Who's respond number 3?
A. Fukon is appearing for GAD, my lord. Today, for some personal difficulty, is not present.
No, it's not a question of that. Who is respond number 3?
Is deputy DC.
He appears for district commissioner,
Commissioner, the district commissioner, we have filed.
correct? The
One,
stand
my
is-
lord, is yet to file.
stand is incorrect.
We have filed it on 16 to 24.
No, but we look at this. This stand is incorrect.
Sorry, Your
On,
Lordship.
on that is, on the ground taken. Affidavit of respond number 3. This appointment has to go. Look at this. Give the second file.
I'm sorry, Lordship, I'm,
Sir, problem. Can you? This is not. ठीक है. Now you're getting the voice.
yes,
Yes.
You see, look at affidavit of respond number 3, paragraph number 9.
paragraph number 9.
Yes, the advertisement is at page number. Which was the page? Advertisement
23.
23. What is the post advertised?
Head assistant.
Head assistant. Now look what you are writing. So 6.2 is applicable. You are referring to 6.5 for junior assistant. Therefore, it's wrong. That's number 1. Second point is that as per the district service, this ministerial service rules, the composition has to be the chief secretary.
Six to eight.
Lordship, let me get a clarification from the department.
No, they will just now make it up. You give an opportunity. Because the affidavit is clear. If the affidavit is false, then you take departmental action against this person.
I contact.
Lordship, if I may, be allowed to file an additional affidavit.
No, you can't improve. You can elaborate, but you can't change the stand. That is not permissible. Elaborate, we can allow you. But to change the stand and now refer to any other provision under the service rules, what is the constitution of this? What is the selection committee comprising of?
Election
Where
committee lordship.
Where
In
is that?
presence of the district commissioner lordship.
Where is that?
Election,
On receipt of application, the selection board consisting of a deputy commissioner, division officers of the district concerned shall assess the respective merit and ability of the candidates for the purpose of according the names of suitable candidates to the commissioner. Thereafter, the deputy commissioner, I'm reading for page number 56, annexure 1. Note, the second note, and the sub rule. Thereafter, the deputy commissioner shall forward the recommendation of the selection board together with the character rule and other relevant papers concerning the applicants to the commissioner concerned who shall make the selection strictly on merit and make the appointment.
6 5 yours, eh? 6 5 6 5.
UDA. Seniority comes 6 4.
No, there's a selection board. What is the constitution of the selection board? Selection board is different. That selection board you will find at note appended to 6.2.
9 6 2 3 1 7. We can.
You have the service manual with you.
Your Lordship, they have actually annexed this in the affidavit itself.
No, they are not referring to 5.
They're not, maybe it's a typographical mistake.
No, it can't be a
One
mistake.
thing, my lord, so far as this para 9 is concerned, probably, my lord, this whatever amendment has been made in para 12 and 13, that has been replied. And 12 and 13, my lord, they've written about, my lord, junior assistant. That has been replied, my lord. No.
Reply to
Regarding
regarding junior assistant.
junior assistant, senior assistant. Lord Civil Seat Expedition para 12 and 13.
Look at this service manual.
Assembly post line.
First of the 6 2 first of the year.
In the note, come to next page, you will find that the commissioner now, they will decide and then send to a board, selection board.
It will UDA 8 by the deputy commissioner writing a plate. It will have. Note for it. In the names of suitable candidates to the commissioner.
Yes, to the selection board, together with
Forward the recommendation.
relevant papers. What is the selection?
Now this page 25,
Page 25.
third paragraph, no, sorry, second paragraph. Candidates who have not completed at least 10 years of service as senior assistant, including supervisory assistant in different branches of the amalgamated establishment, need not apply. Need not apply means their application is automatic or they can't apply.
They can't apply.
They cannot apply. Need not apply, Your Lordship. They are not eligible for the time. If they do not have the 10 years, they should at least have minimum at least
10 years.
10 years of service as senior assistant, including supervisory assistant in different branches of the amalgamated establishment of the office of the deputy commissioners in the state of Assam. Need not apply. So those who have not completed that 10 years mandatory period, they need not apply at all.
What does your affidavit say with regard to the 10-year service? What is to be counted? Confirmed service or ad hoc service also?
Lordships.
The temporary service would not come to the
No,
header. If that be so, the petitioner says that they have put in only 9 years of service.
Your Lordship, here at paragraph number 9 of the affidavit, we have stated that with regard to statements made in paragraph number 12 and 13, the department stated confirmation of service as junior assistant is not a predefined condition for promotion to the
It can't be, that means you're selecting persons who are ex-cadre.
Your Lordship, the condition laid down in Rule 6 of Clause 5 of the Assam Municipal District Establishment of 1967.
6.5 will not apply, so no point reading that.
Then, Your Lordship, the respondent further expressed state that there is official delay in the matter of confirmation in service as junior assistant in respect of respond number 4. But it is not due to the failure of the incumbent to qualify the confirmation. Further, no any objection has been raised earlier by any employees of the establishment, including the petitioner number 1 and 2, even after circulating the draft gradation list to the employees, which is generally circulated every year, to raise written objection, if any, before final preparation and circulation of the gradation list. That is what is stated. But nothing with regards to what your Lordship has raised the query.
But what is the law? The last date of application, the qualification will be on that day.
Yes, on the last date of submission of
Last day of
application.
submission. So whether you consider it after 1 year or 5 years. This can't be saved. So Lata, you are appearing for the private respondent.
Yes, respondent 4. Your Lordship will see that as per 6.2 of the civil rules, this states that UDA assistant with at least 10 years of service as such to their credit, including supervisory assistant in deputy commissioner's establishment. So regarding,
In your affidavit, you don't say that. You do.
I have stated, Your Lordship.
Paragraph 5, Where is that?
Paragraph 5, yes.
5 and 6. It is
Yes.
the date on which you had that qualifying years of service. I don't find it.
As per Rule 6.2, the deponent had more than 10 years of service as senior
From
assistant.
which date?
From 2009, when I was confirmed. That date I have not mentioned here. The deputy commissioner establishment, and since as per paragraph 5 of the writ petition, as Malati Bora withdrew her candidature from the post of head assistant by the order dated 20/2/2023, the deponent was appointed as head head.
There's something wrong then. Yes, page 26 in the evaluation sheet,
Yes.
they say that page number 26, they're showing you at 15/10/2005.
Yes. 15/10/2005. So from 15/10/2005, if we count,
It shows the document of 20 of this 15/10/2005.
that is not there. Your Lordship, we have not annexed that. But here it has been shown that I have joined from 15/10/2005 as senior assistant. So if we count from 15/10/2005, my service as senior assistant has crossed 10 years. So first eligibility criteria is there. And the regarding second eligibility criteria as supervisory assistant.
Just a moment.
Yes. And regarding the second,
Everywhere it is incorrect. You come to page 44.
yes,
Page 44, your serial number is at
my
61.
serial number is at page 42, Your Lordship.
No, 61, Ritu Parna Das.
No, Ritumani Das.
Okay, page number
42.
Ritu Moni Das.
Ritumani Das.
Ritu
Serial
Moni
number
Das.
17.
17.
30 January 2009, date of confirmation.
Date of confirmation is, yes, 30 January 2009 as junior assistant.
So no way you can save this appointment.
But before that, I was promoted to the post of senior assistant, 15/10/2005, the next column. I was confirmed as junior assistant later. But before that, I was already promoted as senior assistant. 4 years prior to that.
Could not have been, ex-cadre could not have been promoted.
Because your lordship will find the reason in the affidavit filed by the government.
No, does this, no, reasons may be there,
Yes.
but does the rule permit that? Some ministerial service rules, does it permit? Supervisory assistant is 6.3 or 6.4.
6.3. No, regarding supervisory assistant, this eligibility criteria no one is having from the petitioners.
No,
Neither the
there should be
petitioner.
administrative order relaxing that condition. Unless it is relaxed. You see, you are confirmed in the junior assistant in 2009.
9.
You could not have been given a promotion in 2005. If you have been given promotion in 2005, for the purpose of next promotion, it can't be counted.
But your lordship, they have stated the government that there was some fault which has arisen due to the.
This has to go back.
We have stated in our affidavit that there was some.
No, but
delay.
ex-cadre, how can you promote? Everything is, something is wrong somewhere. Because as a government, you record your stand. We take your stand into consideration that the government is now taking a stand that even before one person becomes a member of the cadre, he can still be promoted. We record the statement and change the service rules. We directed the state legislature will change the governor would change under 309, would have the amended.
And your lordship, regarding the supervisory assistant, the petitioner is also not having that at the time of at the time the advertisement was issued.
No, that's okay. So he also doesn't get,
So he also doesn't have.
but still they can successfully lay a challenge to your appointment, because this would be a writ of quo warranto.
Your lordship, regarding this point, I may be granted some time.
Can you improve it? You can permit you to elaborate. But can the court permit you to change the stand?
If I can find authority in this point.
There is
then-
none. You cannot be permitted to take a contradictory stand. The only thing you can take as a respondent, a contradictory stand, when there is a contradictory law which is in your favor. You see, you can, for example, you say that you are getting this by virtue of rule X. And then you also say by virtue of rule Y, I also get that same benefit, but in a different manner. So if you are, if the law gives you, permits you in a service matter, essential legal provision by virtue of which you can take a contradictory stand, then yes, obviously. We have authorities on that. That judgment is Mahila Ramkali. But you are permitted to take a stand if law permits. That was a case where a unique thing happened. And that's why I remember that. There are two rounds of litigation up to Supreme Court, right from trial court. And the third round, the Supreme Court found that the law permitted them to take a plea because of the fact that once he is a settlement holder, then devolution of right in Karnataka would be in a totally different way. So on that circumstances, court said that, well, you can amend your amendment can be allowed, and that amendment was allowed after 40 years. That is something unique You can only say that it was under the facts of that case. That was amendment after 40 years. After 2 rounds of Supreme Court, maybe 3rd round. I think the lordships in the Supreme Court would have power, but in this court to allow that to be taken, you have to have a very convincing argument. There is none. So we send the matter back to the Deputy Commissioner. He'll re-examine.
Yes.
He'll re-examine and pass necessary orders, looking into the criteria. And communicate the decision within how much time? 1 month?
1 month.
Or you want more, 6 weeks? But just give me that book again. No, not second copy, the book. Mr. M. Sekel and counsel for the petitioner. Also heard. Petitioners S. Number 1 is by Mr. One is by.
What I'm appearing.
Mr. B. Goel and it's standing counsel for the standing counsel for the GAD. Appears for respondent number 1, Mr. D. Boran and government advocate. Appears for respondent number 2 and 3.
2 doesn't exist as of today. As of today, that particular post has been abolished.
Okay, 3, the 2 and 3. First off, it is submitted that the office of the Deputy Commissioner within bracket respondent number 3 has been abolished, and the new authority. But then you have to make corrections. We'll be sending it to.
Your Lordship, I may be allowed to refer, Your Lordship, this provision of seniority.
11.
11, Rule 11. Rule 11(6).
Yes,
May I read, Your Lordship?
yes.
If confirmation of a member of his service in a cadre is delayed on account of his failure to qualify for such confirmation, he shall lose his position in order of seniority in the cadre vis-a-vis such of his juniors as any be confirmed earlier than him. His original position in that particular cadre shall, however, be restored on his confirmation subsequently. So once the position is confirmed later,
You are reading 11.
yes, 11(6), Roman 6. The heading is seniority.
This envisages cadre. It doesn't envisage ex cadre. Look at 6 again. If confirmation of the member of service
In a cadre is
in a cadre.
delayed in account of his failure.
So you see what happens is that you may be serially selected in a process, but for some reason your appointment doesn't come, for some reason. The confirmation after the examination of documents comes 2 days later. So therefore, there is a time limit. What is the time limit? After which this takes place, and therefore you will be down in the ladder.
My lord, it will be there in the rule itself. Otherwise, my lord, in case of promotion and all, there is a fixed date given, say 15 days, 1 month.
No, here it says confirmation. If confirmation of a member of the service, that envisages that he has to be a member of
Yes,
service.
one more thing was regarding qualify. If he fails to qualify, or there will have to be some criteria to qualify. For his fault, if he would not qualify, in that case, he will lose his
He
seniority.
loses
And
seniority.
it will restore momentum, say, for a departmental examination, my lord.
Correct.
Maybe of that sort.
Correct.
In this regard, Lordship, very much important aspect is that
No, but
Lordship,
this has to be
before
adjourned. You'll have to
confirmation
correct
of
it,
her
correct the
services,
cost title.
Lordship,
Otherwise, you're not getting any relief.
she was promoted for the post of senior assistant Lordship.
That's
Before
okay, but
confirmation of her
this-
services, Lordship, as per
But you'll have
rule
to amend
11(6),
your,
Lordship.
you'll have to correct your
Surplus
cost
sheet.
title.
Yes, Lord. I will note it.
So accordingly, on the prayer made by land council for the petitioner is permitted to amend the cost title in respect of the Swan number 3 by providing freshly typed cost title to the AOJ, criminal, civil pending section. The said authority on receipt of the amended cost title. Shall insert the same as page number 7 and 8. And the present page 7 and 8 shall be renumbered as 7A and 8A respectively, after striking it out. So list, yeah, as and when the corrections are made.
Your Lordship, another thing, the post which I am is,
So time is
yes.
very corrected, because otherwise. But you always have option, if you want to argue, we'll permit you. So that amendment would be subject to post facto amendment. If you want to argue, you can, you are permitted. I don't want lawyers disappointed and going out.
Obliged.
Item 8 for orders.
For time being, my lord, by the senior Mr. T.J. Mohanto, thanks, my lord.
Okay. Thank you.
Time being item 2 with 3.
My lord, here in this case, the petitioners are physically disabled persons and they have challenged the interview and selection process for filling of the 511 grade 4 post
Have you
reserved for
checked up,
the-
Mr. Sikdar?
My
The
lord.
service is complete?
My lord,
Have you checked up?
this,
All
yes,
districts.
Okay, because there are many,
my lord, no
many.
affidavit has been filed by the respondent side, my lord.
No, I don't know you, I accept your statement.
My lord. My lord, some
Yes.
private parties appeared, we have served the copies, my lord.
Okay. But this is, prayer is something which we can't decide.
My lord.
The prayer you are making is something we can't decide in a repetition. You are saying that in few districts, marks were, lesser marks were allotted. This is something beyond our capacity. We can't assess and say,
There has been the minutes of the government and the various organizations of the physically disabled persons. And
how do we make a reassessment? The marks to X should be high or low.
My lord.
How we can make an assessment?
My lord, as per the minutes, my lord, my lord, hearing impaired candidate should be served written questions or sign language of interpreter not available, my lord. And the guideline also says that percentage of disability and higher age may be given priority consideration. That also not allowed, my lord.
Something
And
which is,
my lord, there is no strict guidelines of how to assess the uniform pattern of assessment. should be
I'll tell
carried
you, because the interview is something we do day in and day out. Even this week, we are doing an interview. When we are assessing a personality, there are many things which come into play. There may be a good officer or good person, but when we speak to him, it comes out that he's unfit. I'll tell you an example. A writ petition was also filed here. That's why it's a matter which it's now ended. I'm telling it to you because you will understand. You see, we took an interview of an officer in the
Serial number 2, Sunika Bala Roy, BN College, the venue of the examination. Then, my lord, disability 4 out of 5. Then age 1 out of
So
5.
out of 14, she gets 13.
Yes,
Correct.
13. Yes, my lord, for personality, out of 3, she got 7. And my lord, my submission at this stage is that let the government other side file affidavit. Their response.
No, but this is something which you have to tell us how we make an assessment of personality test. The only question is that how can we make an assessment? Because we must, in a writ petition, arrive at a finding that this was fault. This was a faulty process. How do we say that? I'll tell you, there's a honorable judge. I forgot, either from Bihar or Allahabad. In the SAT, his son, who is in class 9, scored out of 1400, sorry, out of 1600, he scored 1580. In your writ petition, where is the breakup given? In the recruitment advertisement or somewhere else, where is the percentage of marks given?
My lord, this list, my lord, there are several columns, name column, then roll number, venue, then marks of various aspects, marks for disability, marks for age, marks for personality.
No, you are showing us only 7
My lord,
and 8. You are saying that marks is 3.
yes,
Where do you find that marks 3? 3 marks is where?
my lord, I have shown in page 130. Marks 3 is, my lord, within bracket, marks for personality, within bracket 03. Here also indicated.
Marks for personality, P.
In the top line, and
Marks
she
for
got
3 out of
7. That is also indicated in page 1. And here she got 13 out of 14. That may be possible, but 7 out of 3. Well, there has been gross violation of the
These two goes.
selection procedure. My lord.
What are the other?
Well, other is that, my lord, there was a minutes of conducting
How to conduct it?
how to conduct the, my lord, selection.
Where is that?
Page 299. 299. Annexure 11. Lordship may kindly have look to the there are some criteria to be considered in the selection process. The second criteria, the association, Lordship got
290.
299.
Yes.
Second criteria, the association desired that the persons of recruitment should be interviewed based only and not written examination. However, for hearing impaired
reading where?
candidates,
You are reading where?
my lord, I'm reading, my lord, there are some condition criteria to be followed in the interview and selection. I'm reading the second criteria. The association desired
Okay.
that the process of recruitment should be interview based only and not written examination. However, for hearing impaired candidates, the association desires.
That's
that
only a
the-
meeting. This is not a policy decision. You went and had a meeting. So
Yes,
in the
my-
meeting, they said that they will consider it.
yes, my lord. They consider, they agreed that the question to the hearing impaired candidate will be by way of giving written questions or written multiple choice questions. This is because possibility of getting sign language interpreters in all districts being very low if the interviews are to be concluded within a stipulated time frame. Also, there are variation in sign languages and some candidates may not know.
So they
the
only
sign
say
language.
that we will
This was not,
consider it.
my lord.
No, they will only say that they will be considered. This is not a policy decision.
My lord, my lord, in the selection process, my lord, there shall be fairness. How the fairness, prima facie that appears that there was no fairness allotted in the selection process. And my lord, in the last but second condition, page 300, it was
Only a
agreed that
request.
percentage of disability and higher age will be given consideration,
No,
preference.
it says
That-
requested the candidates shall be examined by a medical board for verification of percentage. It was agreed by all the associations. So it was an agreement by the association, not by the government.
My lord,
Government did not say that.
my lord, it was the government has agreed, my lord. My lord, this was this communication has been signed by the principal secretary of the government of Assam
No,
Social Welfare
you
Department.
see, everything is minuted. It doesn't, just because a minutes have been signed, does not become a decision of the government.
My lord. Huh? My lord, kindly have a look at my lord the.
No, you see, today you come, you may have a grievance, you may come to the court along with other bar members and give your representation. I will say that, okay, this will be considered. Something happened in the courtroom is not, you don't find it correct. So give me a representation that in your court this has happened. I will say that we'll look into it. Look into it doesn't mean that there's a commitment given. It will be examined because it will be decision will be taken by the competent authority.
My lord, if my lord, the competent authority is directed to make a reassessment, then
Mr.
will also
Sikdar-
our demands may be redressed, my lord.
Mr. Sikdar,
Prima facie, my lord, there is a cross
No.
violation.
after the recruitment advertisement, if there is any change, that has to be notified. It's a well settled law. I think you also yourself argued
My lord. My
that
lord,
once there's a criteria in the advertisement, if you have to change it, everybody has to have a notice of that.
my lord, that huge public recruitment, my lord.
Only these two people.
No, but criteria
Sir,
are
no?
not also followed, my lord.
These two persons, Mr. Siddhar has been able to show page 170, they got more than the allotted marks. So these two appointments has to go.
Lordship, these were done by the Guwahati University, Lordship. So they will
But
be.
whoever does it, when the criteria is 3, you give him, give persons 7. This one appointment has to go. Well, there's only one recorded history I know of. It was the ICS examination of respected Subhash Chandra Bose. He got 101, and the examiner wrote in this paper, the examiner is better than the examiner. So that is only one instance in the recorded history.
Lordship, these were conducted by the Guwahati University, Lordship. So they will be in a better position.
No, but still, if it is wrong, one appointment has to go. This appointment can't be sustained. Serial number 2.
My lord, my humble prayer at this stage, my lord, let the authority, my lord, file affidavit in opposition, my lord.
No, once they are
If
not filing
anything, anything is coming out, my lord, in the
no,
meantime.
once they are not filing it, we're not giving them invitation letter. Once you have started hearing, they did not ask for adjournment.
No affidavit has been filed, my lord, today. Therefore, my lord,
We are disposing of in the same line.
my lord,
Now you see, there's a pattern. Few days ago also, we were faced with the same situation. I am not aware of the percentage of disability in this case. But in most of the disability certificates issued by the government doctors in the state of Assam, they will just check up the schedule. And if the disability, say for hearing impairment is 40%, they will just give 40%. Locomotor disability is 50%, they will just give 50%. In this case, I have not checked up. Because they will look at the schedule and just give the same figure, which is the minimum marks for inclusion in the schedule.
Right.
One can't have that arithmetical error of disability.
well, that may also be scrutinized by the authority. We are not on that, my lord. We are only on the ground that, my lord, the selection process is not free from biasness and, my lord, some disinformity, my lord, is there, my lord, for which we are deprived of. Select list was, interview was conducted district-wise, and the list is prepared, my lord,
No, you
centrally.
see, every community, maybe if you ask for Mr. Sharma's community, you can ask in your community. You'll have a description of a person belonging to the original belonging, who originally belonged to a particular district. And earlier people used to say that he is from that district, and therefore this is his traits. Correct. People generalize. I believe in Mr. Sharma's community as well as in your community, people have some prejudice for a person belonging to a particular area. Correct. Now, please tell me, from the statement made here, can you expose any such prejudice which the person might be having for a particular district? I'll tell you something more. I'm not giving the details because it's a exercise which is in which is highly sensitive. So far as judiciary is concerned, a particular state send their grade 1 papers to this court for examination. And I had the opportunity of looking at about 120 or 25 papers, except for 3 who got very minimum marks. Everybody else failed. So I had called up the Honorable Chief Justice of that state. It was long back, about 3 years, 4 years back. I told him that this is what is happening. So should I do it or I should return the case? Because otherwise, when these particular things are coming to us, we don't find that they are, you see, grade 1. A lawyer should have 7 years of practice. But the trial court exposure was not there. It was apparent from the papers that the trial court exposure was not there. They did not know the land laws. They did not know the civil procedure. They did not know the criminal procedure. They did not know the principles of evidence. And therefore, except for 3 out of 120, everybody failed. So we were advised that no, we send you there because of the same problem here. We find that they are not qualified. So you see, we deal with those issues. We also dealt with one issue where the examinee of a grade 1 just wrote only one line in the entire paper. High Court to Supreme Court, Supreme Court to High Court. That was the entire, all papers had the same narration. Question number 1, all these markings and all, 2 or 3 pages of High Court to Supreme Court, Supreme Court to High Court. And he got pass marks. It was sent for re-evaluation. And then we found that this evaluation, the evaluation itself was wrong. So we had to strike it out. And the question, the point I'm trying to make is not about that particular person. But if two such persons of a district make the same mistake and we award them less marks, can you accuse us of saying that you have a prejudice towards the persons of that particular area? Because even Supreme Court says, our court also there is a judgment. It says that we can have the corrections, the tabulation checked. But when Mr. Sutia, what is the law? Well, you can check the tabulation, but you can't check the contents. We can't send the contents of the question for evaluation, right?
Yes, yes.
So therefore, if you are saying that there is a percentage assessment was wrong, please tell us how it can be done, except for one candidate which you have demonstrated. He has several authorities on the point. He argued on the last occasion.
There is no guideline to follow the informity of the assessment. There is no guideline access. The whole process is illegal, my lord.
Because it is personal satisfaction of the interview board. There may be two interview boards who can have different appreciation. I'll tell you one thing. If a judgment comes to me for appreciation, and if it is civil in nature, my assessment is in a different way. But if I get if another honorable judge who is more proficient in criminal procedure or in IPC, and a criminal matter is sent to him, his appreciation will be different from what I will do. Now, please tell us, it's a subjective satisfaction arrived at by the person who is correcting the paper. Can you say that merely because of less marks are given, he is biased? Second question, can we ask the evaluator that why in this particular case we have given low marks? Because if this question is put to me, I won't be able to answer. Once the matter is over, I sign the evaluation and send it back. If you ask me, what is the basis of giving that evaluation? I won't be able to answer because you don't maintain that diary of that.
Except objective type. Others, evaluation is vary from examiner to examiner.
Just pardon me, Mr. Sigdar, I missed it. What were you saying?
I say, my lord, except the objective type question and answer, others in evaluation of my lord by the examiners to examiners is varied. The Supreme Court accept, yes, maybe varied.
Correct. You heard your argument on that. I remember it.
Well, here in this case, my lord, the hearing impaired candidates, how the interview is conducted, those people, my lord. That is a very serious question. There was no written question. There is no symbol here, my lord, sign interpreter. My lord, how they have conducted the selection, my lord. So, my lord, primarily there is serious illegality, my lord. So, let the authority file a detailed affidavit, my lord, at this stage, my lord.
They're not making that clear. So
And there is order for filing affidavit that has.
No, we can't compel. They're not made a player.
Director examination devolution. That I want to say interview about it.
These things in illegalities occur repeatedly, my lord. Then, my lord, it's very unfortunate, my lord. Privacy, some injustice is caused to these petitioners, my lord. And if this continued, my lord, in future also. For that, my lord, some scrutiny of and examination of this case is required, my lord.
Respond number two, Lordship.
No, one also.
Social justice.
Yes, Lord. No, Lordship, Social Welfare Department is not here.
Social Welfare, I am appearing for 1, 3 and 5.
Welfare
1, 3 and 5.
Yeah.
Mr. PTC Senior Government, additional Senior Government Officer. And Mr. C. Sharma, Learned Council, appearing for respond number 2.
Yes, Lordship.
2 and 7 2. No,
2 and
then you
6, Lordship.
Huh?
2 and 6.
2 and 3.
No, Lordship, 3.
2 and 6. 2 and 6.
Yes,
Okay,
Lordship.
2 and 6. Then Mr. Suthia, you will also appear for 7, 8,
7 interview
9,
board,
10, 11,
interview board
12.
the principal MC college. So interview board is difficult to appear about. Represented by principal.
Okay. Projecting that all these 172 petitioners have a common cause of action. Common. They have come together to challenge the interview and selection of candidates for filling up 511 grade 4 posts reserved for persons with disabilities in different departments. The petitioners claim that the selection process was illegal and arbitrary. The grievance of the petitioners is that the select list ought to have been published department wise in terms of clause 7 of the advertisement dated 30/12/2021.
Okay, আমার instruction হয়েছে।
My lord, my other grounds, my lord, uniformity of assessment, priority given to the age criteria and the disability criteria,
Come to
and
it.
written question to the hearing impairment. Not
We will
given.
come to it.
This may be recorded, my lord.
Yes, yes, we'll come to it. First, the further grievance of the petitioners is that the assessment of performance of candidates by different districts are also not the same. So accordingly, it is projected that a uniform pattern of assessment of performance of oral interview reflects a different marking pattern for the marking pattern full stop in the districts of Goalpara, Nagaon, Udalguri, etc. Higher marks were allotted, whereas candidates belonging to the district of Borpeta, Bojali, Baksa, Nalbari, Kamrup, and Morigao, they were allotted low marks. Accordingly, the candidates belonging to the said districts were left out by design from the final merit list of selected 511 candidates. Prepared on the basis of marks given by the district level interview board. Next, madam. The petitioners project that in respect of the candidates belonging to the districts from where they belong, a few questions were asked and resultantly less marks was awarded. The further grievance of the petitioners is that the interview board also conducted the interview of persons with benchmark disability. We've also submitted that there were no experts in the interview board versus candidates who were suffering from hearing and visual disability. Benchmark, visual and ability. So accordingly, it is alleged that the marks are allotted on a pick and choose basis. By referring to the advertisement, it has been submitted that the total marks, total public full marks for disability criteria was 5, and the total total marks for the age criteria was also 5. For the personality measurement, the full total marks was 3. And for the Viva Voce test, the full total marks was 14. Accordingly, by referring to this page 170 is annexure.
170.
Huh?
Annexure number.
What is the annexure number for page 170?
My lord, annexure 6.
Annexure 6.
Yes, my lord.
Exercise 6. is
One
repetition.
twenty-seven, starting point.
Within
Lordship
bracket.
wants 170.
PP 170. Comma, it is submitted that the second candidate in the said merit list secured 7 marks for personality test. Whereas the prescribed full marks was only 3. So it is submitted that most of the persons who had secured selection were granted marks above 2 up to 3 for the personality test. And similarly, in Viva also, most of the candidates scored higher than the petitioners. Full stop. Next step accordingly. Now, in page 47, you are writing about 6 roll numbers. How do you verify this?
Page 47.
Page 47
Seven.
of the repetition.
Yes, madam.
How to compare this?
My lord, these 7 persons, they are not included in the, my lord. Not in the merit list. They are not in the, my lord, merit list.
No,
But
where is that document?
they are included in the final list.
Where is that document? Where is that document? Where is that final merit list?
Final list, my lord, my lord, final list is there, my lord. Final.
Which annexure?
Annexure 4. In annexure 4, their name and roll number is one. But the name was included in final merit. Annexure 4. Annexure 4 is the 9. আপনার annexure আমার লগে মিশন না।
I think you are not annexed any document because in your affidavit you are saying these are true to my knowledge.
My lord, their name is not in the merit list, but they are in the final list.
No, I understand, but you will show us some document.
My lord,
This page 22 statement
yes, my lord.
is in your affidavit supported by knowledge, not by record. In your affidavit, it is shown true to your knowledge.
I have ended the final list.
The next, the Learned Counsel for
My
the
lord,
petitioner.
page 285. 285, my lord. I have given one, 3, 4, 6, 0, 2090. I have given, my lord, in page 285, the rule numbers in the final list, my lord. I given mark also. They are not in the merit list, but they are included in the final list.
Case number DC now.
890. The last man 2037890, my lord. He is under hearing impaired candidate.
There's something wrong. Just let me make the calculation.
No, earlier, we have received certain instruction, earlier repetition 2981/2021.
Just a moment, I'm making some calculation, just a moment.
On the condition of a person.
Oh, there's something wrong.
My lord.
There's something wrong. Page 285 is the final select list.
Yes, my lord. My lord,
It
these
does not refer to the,
These 7 persons are included in the final list. My lord.
I understand, but you have to show us comparatively that it was not there earlier.
Yes, my lord. In the merit list, their names are not there, my lord. Their roll numbers are not there.
But where do we find that document?
My lord, in
Yes,
the
Mr. Sathya, what you are saying, you got a Paravas comments.
Commissioner person with disabilities. They said, my lord, earlier, my lord, repetition 2981 of the 2021. Admitted on Ivan, the Commission of a Person with Disability Assam decided to directed to decide the issues raised therein in case number on 8 so and so month, which was pending in the office of the Commissioner of Person with Disability. Earlier, perhaps there is a some
2981 of which year?
2021. And another repetition, my lord, is as appears as per appearance or repetition 4323 of the 2023.
WPC 2981 of 21.
Yes,
That's the last order.
2981 of 2021.
And
And another is 4323 of the 2023. The Commissioner for Persons with Disability Assam recalled the order 96/2022 as there is no statutory powers. We have to go to repetition, what is this?
my lord, these 7 persons in the final list, not in the merit list. That is our stand, my lord. Let them show that they are in the merit list.
Number list. 203891.
Yes, no comment. Yes.
There's something wrong in your drafting. You look at paragraph 13. In paragraph 13, you are referring to this candidate who has awarded 7 marks. That means here you are referring to page 70, but your final merit list is annexure 8. In respect of this annexure 8, you don't say the anomaly. That statement you are making it paragraph 22. What the order? Read the last order in that matter. Just check up some inquiry was ordered. That particular order we want. Resume transmission. No. What is the date of the order, Mr. Zutya?
That is, order date is,
First dictation you said 2981.
2981, Mr. Person Assam directed to decide issues raised in the case number. Order date is not given, Madam.
Not there.
Your lordship, in item 3,
14 September, just give the printout. Let's see.
may I do- in lordship, in item 3, I have anything order. We start from page 248. The order
Item
date
3
is
is WPC number.
2981, 2022. Order dated is 9/5/2022.
That was on 14/9/22, Madam, disposed of. 14 September 2022.
Nine five. Property portion start from 258 in item 3. Yes, sir. Register is mercy shall furnish the comments reply. Complaint submitted by the petitioner. My lord, in the previous order, in this petition, writ petition number 2981 2022, there is an order dated 9/5/2022. And in the operative person paragraph 7, there is a clear direction of this own code to comply with the, my lord, complaint submitted by the petitioners before the commissioner.
We are getting that order.
Next question.
That has not been followed, my lord.
298. 293, 298, yes, next day, I can go out.
No, 2981 of 21
My
is
lord,
a different matter. It's a custom matter.
my lord, that is filed by the association, the Banga
No, no.
Mancha, Assam.
2981 of 2021.
Twenty-two,
a-
my lord, it is
Huh?
22, my lord.
22.
2981 oblique 2022,
22, not this one.
not 21.
We wrote
My lord,
21.
that also enclosed in our writ petition, my lord.
Which one? Which
And
petition?
Annexure 10, page 295. That is-
295.
Yes, well, that is available in our writ petition. Paragraph 6 and 7 is relevant,
Okay,
very
fine.
relevant.
We have it.
And 7, my lord, this honorable court has directed that university shall furnish his comments reply to the complaint submitted by the petitioner before the Court of Commission for persons with disability, Assam, within a period of 3 weeks from the date of the petition. This was also not done. ফাইনালিস্ট আছে মেরিট লিস্ট
This page 127, what is the date of this report?
120. 127, madam.
Yes.
My lord. It was the annexure 6. It was the, my lord, mentioned before the election, my lord, interview and selection process was started, my lord. The
No, but I don't know. Something is wrong again. You come to page 38 of your writ petition. The
My-
copy of merit list is dated 26/2/2022. Correct?
copy of merit list.
Yes. Now, somebody came to court 2981 of 2022. And this says that
It is merit list of, yes, annexure 6.
merit list should not be,
Annexure 6.
merit list should not be published. Because the commissioner is in is in session of the matter. But before that, the order is already been published. So this order, what you call this, 2981 is not a compliable order.
But order in 28. 2981, my lord. That was,
Because here the order is not to declare the result of the exam. That has already been declared. That is why your second writ petition, this present writ petition has come to challenge the result.
yes,
So the first writ petition, the order is non-compliable order.
my lord, my lord,
Mr. Fugan, has any contempt been filed against the order dated 9/5/2022, passed in WBC 2981 of 2022? Are you aware of it? No.
No, my lord. My lord, only one thing I will point out, my lord. The earlier order of this honorable court, dated 3/4/2024,
3/4/24.
2024, in item number 2. Today I filed an affidavit regarding subsequent developments, my lord. You know, the entire petition is revolving around the list of 2022. But on 31/1/2023, the final merit list has been published, my lord, as per direction of this honorable court in other cases, my lord. So,
Has
my
been
lord,
published.
my lord. And thereafter, my lord, the government of Assam in the Social Welfare Department, they have also published one notification on 19/2/2023. These subsequent developments have not been incorporated in the present writ petition. So entire matter has become infructuous, my lord, in view of these developments, my lord. Medical board has examined the selected candidates' appointments are over, my lord. Now they are,
When you bring it on record, we'll have to adjourn it, madam. Mr. Siddhar has to take a call on that.
I have filed an
we
affidavit today itself.
have not given any, we are not aware of this subsequent final merit.
It's
list, but
okay, once he's saying that.
merit
then
list
this
we have
matter is adjourned.
enclosed in page 285.
This matter is adjourned. Mr. PJ Fukan, the standing counsel for the Guwahati University, has submitted that an affidavit in opposition has been filed.
Affidavit, my lord,
An affidavit has been filed by the Guwahati University
today itself.
today to bring on record that the final select list
Mail.
has already been
Published on
Published.
31 January
on 31/1/2024,
2023.
2023.
Mail.
So accordingly, it's submitted that this matter has become infructuous. Next, let a copy of the said affidavit be served on the learned counsel for the petitioners. So matter stands adjourned today to enable them to obtain instructions. List after answering some of the question.
My lord.
Mail. Most of them.
In 3 also items, same order will come. They will start.
I take copy to decision. Most of this.
Your lordship.
Who have not received the copy, give it final. In item number 2.
Item number 2, you did not give a copy.
Had dictated the earlier order, it is on record. The order your lordship had dictated before.
Which one?
In
No, Mr. Sharma is saying that you have not served him extra copies.
No, your lordship has dictated a long order wherein.
No, that goes.
It goes.
That goes. In second item, Mr. Mazumdar,
Yes,
he gives extra copy. In the second item, you say. Learned-
we have already served him. He has acknowledged. Respondent 6.
I don't know, he's saying that he has not received.
No. 3.
Mr. C. Sharma. Learned-
Yes, I have already served. Respondent number
counsel
3.
for, You're for which department?
And for social justice and.
For Social Justice Department. Something that he has not been served with the extra copy of the petition. So the same be furnished to him within 2 days. Okay.
Obliged, my lord.
Item 9 for hearing.
Yes, Mr. Nayak. You're saying that under RTI, they got the
In 2005.
in 2009, ACRs, they were downgraded.
Yes, Lordship.
Have you filed a affidavit saying that you had communicated that to them?
Lordship, today this matter has been allotted to one of my colleague, Lordship, Rahul Lord. I'm sorry, Lordship, I'm not heading that way. Sorry.
But Mr. Lord, there's only one question. The case of the petitioner is that the ACRs, they were downgraded. Whether that was communicated to them in appropriate time.
That, my lord, in my affidavit, I am silent regarding that communication part, my lord.
It has to be revisited by the authorities once they are not communicated. The downgrading. The ACR. This is the only point here.
The only point here is whether it was communicated, my lord.
That is at page 35, sir. That downgrading lot will find at page 35. That minutes, actually. It's the minutes, lordship. And therein
55.
35, lordship.
Oh, 35.
Part of the minutes dated 9/6/2022, lordship. Herein, I got this through RTI, lordship. That was RTI reply they gave on 3/5/2014 and 12/5/2014. I got the RTI reply, lordship. This selection took place in 2002 itself. And therein, lordship,
Which page? Which page is the relevant entry?
lordship, it's at page 35.
35, where?
Lordship, serial number 77.
That marks 4+3+4+3+3.
4+, yes, lordship. that
Yes,
was
now you are what?
Now that 3+3 at the end portion, lordship, that ought to have been 4+4, lordship. Because,
You're saying that from where?
yes, lordship.
My lord,
Lordship may kindly turn page 50.
50.
50. Lordship, for outstanding remarks in a year.
Just now. $50.
50.
50 is just a form.
Yes, lordship.
Yes.
Therein they have marked at the beginning itself, lordship will find that it's outstanding. That was on the part of the
50. There's something wrong. Oh, outstanding.
outstanding, lordship.
Okay.
So I was marked outstanding for in the ACR for the year 2000-2001, lordship. And this was by the reporting authority, lordship. This remark was given by the reporting authority. Subsequently, reviewing authority did not review that. And at the bottom portion, lordship will find the accepting authority changes to very good, lordship. Without any reason.
You're reading where?
at the bottom portion accepted as just below
Accepting authority accepted as proposed by the record
reviewing reporting
very
of
good.
very good lodging. So admittedly, it was outstanding. That was changed to very good without recording anything. And in the DPC held lordship, marks assigned for outstanding remark was 4, and for very good it was 3. So I was
From where
given
you are
3.
saying that,
Lordship will again turn to page 35.
okay,
At the beginning portion, Lordship will find for good 2 points. Beginning portion, Lordship has found that.
this, how many petitioners are there in this writ petition?
Only one Lord.
One, my lord. He has retired in the meantime, my lord, and he retired as additional chief engineer.
This breeding has to be restored and he should be given financial
And
benefit.
subsequently for the year 2001, 2002 also Lordship, the same thing happened. That Lordship will find at page 61.
This,
Page 61.
this is ACR of
This is
25/5/2001.
Which one, Lordship?
This is for which year? Page 15.
Page 50 is 2000, 2001, Lordship. 2000 and 2001.
Yes. Second one.
The second one is of 2001 and 2002. Page 61. 57, Lordship, I'm sorry. 57.
I think that is 54.
It starts at 54, Lordship, and in page 57, Lordship, the reviewing authority marked graded me as outstanding. Page Lordship has got it point number 4.
67.
57. I'm sorry. Your Lordship got it. Point number 4, it was written as outstanding, Lordship. Subsequently, the accepting authority accepted it as very good, Lordship. And in their affidavit, Lordship, at paragraph 9, Lordship, with regard internal page 5, paragraph 9, with regard to this, they have replied. Basically, Lordship, they have accepted that fact, Lordship. And with regard to non-communication of those SCS, we did not say anything, Lordship. One more grievance I raised at paragraph 13 of my petition. Yes. Lordship, one more grievance was there. At paragraph 13 of the writ petition, I have stated that in assessing the ACR for 2001 and 2002, the reviewing authority and the accepting authority was the same person, Lordship. And that same person cannot have given me very good outstanding remark once and changed it to very good the next.
Oh, same person,
Yes.
2001, 2.
2001 to Lordship. They did not reply to that, Lordship. Paragraph 13 of my writ petition. If I prepared a small note containing the list of dates, may I forward that? And I'll be relying on some decisions and
Yes.
those also I am forwarding. Lordship, the case of Devdutt, I'll be.
Devdutt.
Devdutt, Lordship. It's 2008, 8 SCC 725.
2008.
Volume 8, SCC page 725.
2000.
2008, 8 SCC 725.
Yes.
Lordship, I will be relying upon paragraph 10, 14, 18, 19, 20, 39, 40, and 47.
Para 10.
Paragraph 10, I have written it at page 3 of that note, Lordship will find that. Serial number 25. Lordship may need not.
Okay.
Lordship,
Pass orders when I resume again at 2 o'clock.
I'll be relying upon some more decisions. I'll place it.
Resume at 2.
Lordship.
Lordship, I beg to mention one item, item number 18. Actually, to become impressors, we have been promoted during the pendency of the repetition. One good news. At least one disposal.
Item number
18.
18.
18. 18. 18. I think.
Third. This calls are any learned counsel for the petitioners. As Corporation Department will be there.
MD Boraman.
MD Bharat, and it's universal for the Corporation Department. And for government who will be there. You're
I
there. And Mr. Ardhar, and additional senior government advocate appearing for the state. Next, madam. Upon instructions, the learned counsel for the petitioners has submitted that during the pendency of the petition, the petitioners have been promoted. Accordingly, the matter has become infructuous, and he has instructions not to press the matter. Next paper. According to this matter, dismiss as not pressed. On satisfaction.
I'll do.
The other members of the bar, Mr. Mahanto, to all other members of the bar, I may not be able to take up any other matter. Suddenly I have a running temperature.
I understand, my lord. So my matter may be tomorrow or day after tomorrow.
Tomorrow, I may have to take.
I understand, my lord. I have seen, my lord. Yes, I've seen.
Day after, Lordship.
Day after.
I can see.
My lord.
Let me check up after I rise. I will give
My-
you dates. You have urgency in the matter?
Day after tomorrow, there is no idea.
Okay.
But earlier order shall continue.
Okay. Entry order extended.
Yeah. Item number 8.
Item number 8.
My-
Who's for the respondents? Government.
No,
Will be there?
Yes, Lordship.
Okay.
Yes,
Mrs. M. Bhattacharya and government advocate.
We have received the record also, Lordship.
Huh?
Received as Lordship has confirmed the record.
Okay. It is submitted that the relevant records have been received. Next, list one, so
Mine. Biplab.
If we have placed.
Item 9.
What is the other citation in which you want to rely?
Lordship, that is 2013 SCC 566 Sukhdev Singh, Lordship.
Hmm?
That judgment, Lordship,
Which one?
that is Sukhdev Singh. Thousand 13 SCC 566, Lordship. In paragraph 2, there is one observation, Lordship, that will help me.
Paragraph?
Paragraph 2. Subpara 3, Lordship. That was what was observed in UP Jal Nigam case, Lordship. And that was
UP
taken-
Jal Nigam is better.
Yes, Lordship. That was taken into consideration by these 3 bench judges judgment, Lordship. And may I read it once, Lordship?
Okay, this is a larger bench. That's
Yes.
fine. UP Jal Nigam was 2-judge bench. Now this is 3-judge bench.
Yes, Lord.
Okay.
And the other 2 is 2014 5 GLT 396 IA Lordship. I'll be relying upon paragraph 16, 18, 19, 20, 28, 29, 30 and 31, Lordship. Lordship, in paragraph 30 and 31, there is an observation.
So there is a judgment on downgrading. Which one is the
Lordship.
judgment on downgrading? This is not that judgment.
That
Down-
was,
Downgrading has to be communicated.
yes, Lordship, that was what was upheld in Sukhdev Singh. It was there in that case of UP Jal Nigam. Lord. If Lordship takes up Sukhdev Singh paragraph 2, subpara 3, that will be clear, Lordship. May I read, Lordship, Sukhdev Singh?
No, this is adverse remark. There's another judgment which refers to the downgrading must be communicated. There's a specific judgment. Downgrading
There,
has to be.
Lordship, just 3 lines from bottom of that paragraph, Lordship.
Hmm.
3, no, it will be 5, 1, 2, 3, 4, 5 lines, Lordship. It may be emphasized that even a positive confidential entry in a given case may previously be adverse, and 2, say that an adverse entry should always be qualitatively damaging may not be true. In the instant case, we have seen the service record of the first respondent. No reason or change is mentioned. The downgrading is reflected in by comparison. This cannot sustain. That was held, Lordship. So that changing of
You are reading which part?
paragraph 2, subpara 1, 2, 3, 4, subpara 4.
4, yes,
It's a continuation of the
yes.
third paragraph.
Which part?
From bottom 1, 2, 3, 4, 5, 5th line, Lordship, from the bottom.
All the same.
Yes, I'm reading from there. All the same, the sting of adverseness must, in all events, not be reflected in such variations, as otherwise they shall be communicated as such. It may be emphasized that even a positive confidential entry in a given case can perilously be adverse and to record. To say that an adverse entry should always be qualitatively damaging may not be true. In the instant case, we have seen the service record of the first respondent. No reason for the change is mentioned. The downgrading is reflected by comparison. This cannot sustain. Having explained in this manner the case of the first respondent and the system that should prevail in the Jal Nigam, we do not find any difficulty in accepting the ultimate result arrived at by the High Court. Upon comparison, it was seen that it was downgraded. He was downgraded in that case. In this case also, the reporting authority, although had given me outstanding loss, the accepting authority had changed it to very good, and that was not communicated. That was held to be not sustainable. Lordship, another two judgments are there.
Yes.
That is 2014-5 GLT 396.
Yes.
Lordship, I will be relying on paragraph 16, 18, 19, 20, 28, 29, 30 and 31. Lordship, in this case, 28, 29, 30 and 31, if Lordship peruses, that will be relevant, Lordship. The other I will not press, Lordship, otherwise. Lordship, paragraph 21, may I read that, Lordship?
Yes.
The nomenclature of an entry or grading in the ACR is not relevant. What is important is the effect of such an entry, and that is the test which will determine whether the entry is adverse or not. Thus, it is the rigors and effect of the entry which is of paramount importance and not the phraseology. In the instant case, the benchmark for promotion was minimum 3 very good entries and 2 good entries. The good is not good enough to enable the petitioner to earn promotion, and in that context, there can be not two opinions that the good entry in the context of the case is in fact an adverse entry. Paragraph 29. It is imperative that every entry in ACR, poor, fair, average, good, very good, outstanding, must be communicated to a government servant within a reasonable period. Non-communication of an entry is arbitrary and violative of Article 14 of the Constitution. 30. The affidavit of the respondents is explicit that the DPC graded him unfit for promotion, as the petitioner could not achieve the benchmark grading. Non-communication of the entries, more particularly the good entry, deprived the petitioner of making an effective representation. Based on
This is
such,
repetitive because this is there, Devdutt is same thing.
yes, Lordship, but in this case, what the Honorable Court did was that at paragraph 31, Lordship will find that. In view of the discussions above, the good entries in the ACRs for the year 2006, 2007 and 2007, 2008 are expunged, and the same are directed to be treated as very good. The respondents are directed to hold a review DPC to consider the case of the petitioner for promotion to the post of second in command with effect from 1/6/2010 within a period of 3 months from today. So the gradings were expunged, Lordship, since it was apparently illegally done. And in the other case, Lordship, that is Sanjeev Rajan, I did not find a citation, Lordship, but then it's a judgment dated 14/3/2017 passed in WBC 2762 of 2011. Herein, Lordship will, although there are many paragraphs which are relevant, Lordship, I'll be.
No, all those cases follow the Devdutt.
Yes, yes.
That is the other case.
Paragraph 24, I'll be relying, Lordship, for Lordship expunging that adverse remark and
That
also.
follows from Devdutt also, same thing. Devdutt also gives the same relief.
Lordship, Devdutt just said that the department may consider, Lordship, but in this case, I am praying that Lordship will expunge those adverse remarks and upgrade the remarks which were forwarded by the reporting authority. That remark may be treated as the one that is to be considered lordship. And I also pray lordship.
Counsel for the petitioner.
My lord, I just want to show one thing, my lord. Please, so my lord, complete, my lord. If he has completed, my lord, just I want to bring, my lord, page 48. That SCR, my lord.
Yes.
Page 48 of the writ petition, my lord.
Yes.
My lord will find in the last part of this page 48, my lord, assessment by the reporting authority, my lord.
Yes.
So, my lord, you will find first that is state of health, that is good. Then the next page, my lord, arrangement of works, very good and efficient. Intelligence, very good with high intelligence. Then, my lord, attendance, regular, punctual, very good. Next is good character. Next is then the next knowledge of law and these things, my lord, very good. Then excellent. Then again, very good. So, my lord, as a whole, my lord, you will find, my lord, we have to read, my lord, each and every, my lord, assessment, my lord. There are most are very good or good. That is why, my lord, the reviewing authority has taken it as a whole, my lord, as very good, my lord.
That cannot be lordship. Because
That is how, my lord, SCR is read, my lord.
in the DPC itself, the markings are given.
My lord will find the entire assessment, my lord. Only in this designation, page 50, outstanding capable, that outstanding is only here. In other all columns, my lord, it is efficient, very good, good. These are the, my lord. So as a whole, my lord, that is why, my lord, the reporting authority has taken into account as very good. He did not, my lord, cherry pick only one column, my lord.
No, that's okay. Nobody said that you don't have power to downgrade.
No, we did not downgrade, my lord.
No, it's okay. You see, whatever you have done, the accepting authority has done.
My
it
lord.
could have been communicated, end of the matter. They could have given reasons and been communicated.
That communication part, my lord,
Nobody-
but otherwise, my lord, we did not downgrade. What is
Nobody
there
says-
in the thing, my lord, we have taken as
No.
some of
I'll
the,
give you a very small example. I'm good at giving horrible examples. This is one of them. You see, two examples. First is that you ask somebody, just for example, Mr. Chaudhary sitting behind. Correct. And no, don't stand up. I'm just saying, no, you don't know him. I ask you that Mr. Chaudhary is coming from Delhi. How is he? If you don't know him, you will say he's very good. If you know him, you may say good average. You can tell him that my experience with him was not good. But when you don't know about anybody, you will say he's good. This one. Second is that I may rate a person when I'm filling up an ACR. I may say everything is good. But when in the last column I come, there are 4 categories. Very good, outstanding, excellent. These are 4 things. So there I take up 1. Now, if that taking up gives him some advantage, the authorities can say that, well, the reason for giving him outstanding is not apparent from the ACR, and therefore I'm downgrading it to very good in terms of the various remarks column in the ACR. I'm giving him good. Nobody is questioning your authority. But you would have communicated under the matter. Nobody would have questioned you.
then my lord, prayer would be, my lord will send back to the government, my lord, authorities, my lord. Because in the next event, I found the same thing, my lord. In page 54, They are also, my lord, similar thing, very good, very intelligent.
No, that's okay. You see,
So that's why, my lord, the ultimately very good was given. That is the thing. We did not downgrade. We just took a sum of the, my lord,
no,
assessment.
nobody is saying that you don't have power. Please exercise that power. But after Devdutt, you don't communicate. That's why we are questioning it.
During the
No, I was telling you about two examples. I will give the second example.
My lord,
Now, Mr. Chaudhary asked me about you.
my lord.
So, I found him arguing in the courtroom. How is he? And I give a reply, Mr. Dhar. Okay, well, very good. Lesser said is okay. I don't say anything. No comment. Now, what is more adverse? When I'm replying of assessment of someone, I start and then I say, no point. Let us not talk about Mr. Dhar.
My lord.
Now, whether according to you that is an adverse comment,
Obvious, my lord, advertisement.
why? I did not say anything.
But my lord, we said here, we said
No.
very good.
This is my second example. I'm saying that even by not saying something, we can communicate a bad remark.
But we here, my lord, we have.
That's okay. This is the second example I was trying to give.
My lord.
That even without saying anything, we can still communicate a bad remark. And both the examples, I take it back. It was just for a lighter note, not for your assessment of you two. I regard both of you well. It's just an example I am giving.
Lordship, one thing I would like to add. Here in Lordship at page 35, what DPC considered is
So
the
we have taken note of that.
fourth
We
paragraph.
will
Lordship.
not be detained. This may not detain us.
Lordship, during this
Just a moment. You have to reserve it.
he retired Lordship,
If I, yes, sorry.
and
He
he
retired,
also,
my lord, as additional chief.
he also got
Mr.
some
Adhar
promotions.
Planet, Additional Senior Committee Advocate. We are appealing for all the respondents. Appealing for all the respondents. It's correct. Whisper at the outset. The learned counsel for the petitioner has submitted that during the pendency of the repetition, the petitioner has superannuated. So.
On 34
On 30?
34 2020.
34 to 2020. Just we
As,
take note of the said submissions. Next paragraph. By referring to the ACR of the petitioner for the year 2000-2001, 2001-2002. It is submitted that at the relevant point of time, the petitioner was serving in the Public Works Department as an assistant executive engineer since 10/3/1992. Full stop. The reporting authority. It is called reporting or recording?
Reporting.
Reporting.
No, because in page 50 you are writing recording.
It's reporting, my lord.
Sorry.
The reporting of the recording authority. By an endorsement dated 25/5/2001.
Reporting.
Means to whom you report.
Which page 48.
Rated the petitioner as outstanding with a further remark that he was capable of handling multiple projects at a time. Full stop. The accepting authority accepted the proposed remark by the reporting officer as inverted commas very good. Full stop. The said remark was signed by the secretary, PWD, by an endorsement dated 5/6/2001. Full stop. In respect of the ACR for the year 2001-2002, the reporting public recording authority was the additional director within bracket building DLDG full stop design bracket closed in the office of the chief engineer, PWD building, where by an endorsement dated 2/5/2002, the general opinion of the reviewing authority in respect of the petitioner was graded as outstanding. Full stop. The same authority, i.e. the additional director within bracket building design bracket closed, PWD, was also the accepting authority, and by another endorsement dated 5/6/2002, the remarks of the accepting authority was inverted commas accepted as very good inverted comma closed. But something is wrong here.
5/6.
Page 57.
Kindly see the handwritten one, it's at page 60.
No, earlier he signed as reviewing authority.
Yes, Lordship, but then at paragraph 13, I have said that Lordship, he got promoted as secretary, Lordship.
Recording authority endorsement is dated. Yes, reporting officer is giving you what? Yeah.
In this year, Lordship, there was no such remark, Lordship, from the reporting authority, but he just stated that he was very efficient, Lordship, that much only. Subsequently, it was reviewed by the reviewing authority and it was
Okay.
stated that he got.
Take it out. So that as per the endorsement by the reviewing of the recording authority, no, sorry, reporting of the recording authority, the remark for the petitioner was given as very efficient and capable. Most of the said remark was given by the additional director with the bracket building design, close, PWD, full stop. However, the same authority, i.e. the additional director within bracket building design, by his endorsement dated 2/5/2002, as the reviewing authority, graded the petitioner as outstanding. Full stop. However, the secretary, PWD department, by an endorsement dated 5/6/2002, gave a remark as an accepting authority to the effect, inverted commas, accepted as very good. Inverted comma closed. Full stop. Next, the learned counsel for the petitioner, by referring to the minutes of the selection board's meeting held on 19/6/2002 for promotion from assistant executive engineer to the rank of executive engineer, PWD within bracket C. Had taken the ACRs of 5 years. Full stop. As per the submissions made by the learned counsel for the petitioner, based on the criteria of outstanding and very good, respective marks allotted to the petitioner was 4 + 3 + 4 + 3 + 3 is equal to 17. So it is submitted that in the last two ACRs of the year 2000-2001 and 2001-2002, the petitioner was given 3 marks each in view of his grading as
Very good.
very good, whereas he was granted 4 marks in the ACR for the year 1999-2000, where his grading was very good, excellent, and he was given 4 marks. Full stop. Accordingly, it is submitted that the reporting public recording authority had given a remark of excellent to the petitioner, and when the accepting authority accepted the said remark as inverted commas
Very good.
very good, inverted comma closed, comma, the said non-communication of the remark of inverted comma very good has deprived him of the of consideration of his candidature for promotion. Full stop. The petitioner projects that he got the copies of the relevant ACRs only through RTI, right?
Yes, Lordship.
So
That I
RTI
received
reply dated
RTI reply dated 3/5/2014 and
12/5/2014
and 12/5/2014.
and 12/5/2014. And despite there was this was a advocate's notice.
Yes, Lordship, it's of 15/5/2014.
And that despite issuance of
Yes, sir.
advocate's notice dated 15/5/2014, as the grievance of the petitioner was not addressed, the present petition has been filed under Article 226 of the Constitution of India. In support of the submissions, that the groundbreaking of ECR is required to be communicated. The learned counsel for the petitioner places reliance on the following cases.
Not sure, I have given a note there in SCC citation is there. Lord.
Next one. Opposing the prayer made in this repetition, the learned standing counsel for the PWD has submitted that on a perusal of the ACR for the year 2000-2001 and 2001-2002, in all the relevant entries, the reporting or the recording authority had never given a remark of excellent to the petitioner, excellent or outstanding to the petitioner, and therefore the final opinion of grading the petitioner as outstanding was rectified by the accepting authority by accepting the proposal of the reporting officer as inverted commas very good. So accordingly, it is submitted that there was no error or mistake on part of the respondent authorities, and the petitioner was given a grading of what was apparent from the contents of the ACR of the two relevant years. So accordingly, it is submitted that the petitioner has not been able to make out any case, and therefore the petition of the petitioner is liable to be dismissed. Next paragraph. The law regarding communication of the ACR is well settled by the pronouncement of the Supreme Court of India in the case of Devdutt. What is the settlement, Devdutt?
Lordship, it's 2008 8 SCC 725.
Okay, yeah, Devdutt versus DEV, DUTT versus Union of India and others. Within bracket 2008, bracket 8 SCC 725.
That would be paragraph 40 में can
So in the case of Devdutt, within bracket Supra, two judge bench on elaborate and detailed consideration of the matter, and also taking into consideration the decision of the Supreme Court of India in the case of UP Jal Nigam and others versus Prabhat Chandra Jain and others, comma, within bracket 1996, bracket close 2 SCC 363. And the principles of natural justice as laid down in the case of as laid down in the Katina judgments, including AK, PRAIPAK, PRAIPAK versus Union of India within bracket 1969, bracket close 2 SCC 262, and other cases concluded that every entry in the ACR of a public servant must be communicated to him within a reasonable period, whether it is poor, fair, average, good, or very good entry. Full stop. The said decision was approved by a three-judge bench of the Supreme Court of India in the case of Sukhdev Singh, SUKHDV, Sukhdev Singh versus Union of India others, within bracket 2013, bracket was 9 SCC 566. By holding that the view taken in the case of Devdutt, that every entry in the ACR of a public servant must be communicated to him or with her within a reasonable period is legally sound and helps in achieving threefold objectives. Full stop. First, comma, the communication of every entry in the ACR for to a public servant helps him or her to work harder and achieve more. That helps him in improving his work and give better results. Full stop. Secondly, and equally important, on being made aware of the entry in the ACR, the public servant may feel dissatisfied with the same. Communication of the entry enables him or her to make a representation for upgradation of the remarks entered in the ACR. Third, communication of every entry in the ACR brings transparency in recording the remarks relating to a public servant, and the system becomes more conforming to the principles of natural justice. Accordingly, it was held that every entry in the ACR, whether it be poor, fair, average, good or very good, must be communicated to him or her within a reasonable period. Full stop. The same principles are found to be followed in the decision of in the two decision of the coordinate bench of this court in the case of Sanjeev SANJEEV, next for Ranjan RANJM versus Union of India and others. Versus Union of India and others, WPC 2762 of 2011, decided on 14/3/2017, as well as the case of I.A. Khan versus Union of India. Within bracket 2014, bracket 6 GLR 342. Next. one. Taking note of the submissions made by the learned additional senior government advocate. We examine the affidavit in opposition filed by the respondent numbers 1 and 2. Proof. Phanindra, Phanindra, Nath Patwari, Patowary, Under Secretary to the Government of Assam, PWRD, within bracket, establishment, B branch. In the said affidavit, it has been admitted as follows. It will. Internal page 3, last part. The ACR point of the petitioner was as follows. Full stop. Therefore, it is admitted by the respondents that on being awarded a grade of outstanding in the year 1997, in the ACR for the year 1997-98 and 1999-2000, the petitioner was awarded 4 points, whereas the mark of very good earned in the ACR of the year 1998-99 and no, not and comma 2000-2001 and 2001-2002 earned him 3 points, and the total marks awarded to the petitioner was 17. Mr. Dhar, in your affidavit, paragraph 8, is it relevant?
Lordship, my submission would be that would come into effect if 2003's consideration against 3 vacancy of the chief engineer, Lordship, that would have been considered. But I am claiming against the vacancies of 35 vacancies of 2002 itself, Lordship. So Lordship, that only if Lordship finds that I am not eligible in 2002, then only that would come into consideration, Lordship. Since my juniors, Zulfikar Alam Hazarika, Lordship, he got promoted in 2003. So subsequently, before retirement, Lordship, he served as commissioner. So at least
The commissioners, chief engineer, these are by selection, my lord. After superintendent engineer, my lord, he cannot just claim, my lord, that by seniority I will get.
No,
a
not that.
promotion.
I'm just trying to understand how relevant is paragraph 8 in this matter. Because the first hurdle is the ACR.
Yes, my lord.
From assistant executive engineer to executive engineer.
Yes.
So at this stage, I don't find this relevant. This will be for subsequent consideration.
This is for subsequent, my lord. But we have, my lord, just refer the rules.
Okay.
if those ACRs would have been considered, then even after promotion to
My lord, one thing, he, 2001 and 2, he has come before this court in 2014, my lord. All these years,
They
my
did
lord.
not communicate lordship, otherwise.
He did not disturb you. No, that's okay. He gave a reason.
All these years he remained silent. He, in between, he got his other promotions, my lord. At the fag end, my lord, he did some calculation and he came with your lordship, my lord. If he was agree, my lord, he should have, my lord, 2001, my lord. In between 13, 14 years, my lord passed. He remained silent. That is a very vital aspect, my lord. He just cannot say that he was sleeping over his rights. And by 2014, he was a superintendent engineer. He already, my lord, he's got his 2 promotions in between. And he retired as acting, my lord, chief engineer of building.
There are many people who don't want promotion.
That is also
Service. I find many people who don't want promotion.
They are, my lord. So that part also, my lord will just record my submission that from 2002 till 2014, he remained silent, my lord. He obviously knew that he did not get a promotion, my lord, but he remained silent till 2014. And in 2014 only he has come before this court, my lord.
Mostly in your affidavit, it's not there. That spell is not there.
Yes, but my lord, I am just.
Yes, we take consideration.
Even he filed his RTI, my lord, in page 26 in 2014.
That was not there at that point of, in 2002, lordship RTI did not come.
But my lord, 12 years he sat over his rights. In between, my lord, he got 2 promotions. And my lord, at the end of the day, my lord, he retired as he was an additional chief engineer, retired and holding the charge of chief engineer, acting chief engineer for 3 months.
Please, that benefit be given lordship of chief engineer lordship. Admittedly, lordship, all the juniors who were there.
That
No,
is
Mr.
absolutely
Nithar, you're taking a ground in your affidavit that in the ACR,
my lord.
there's no opinion required to be expressed by a reviewing authority, by a reporting authority.
My lord.
In page 56, the authority, the recording authority does not say. It is your reviewing authority who gave him excellent.
Page 57, my lord.
Page 56, the authority does not give him excellent. Reviewing authority in page 57 gives outstanding.
Yes, reviewing authority gives him outstanding. Very efficient. It is, my lord, in page 56. Was, my lord, if you go by page 54, part 2, my lord, in the bottom, my lord, assessment by the reporting authority, my lord. My lord will find the name Sri such and such, my lord, executive engineer. And in page 57, reviewing authority, the same person as an additional chief engineer. Maybe
10%.
he was an executive engineer then, my lord. He got promoted
but-
and
But he gave 2 reports. Same person gives outstanding and then says, page 57, he gives outstanding, then gives again accepting authority. So it's not the case that the reporting authority give that.
my lord.
Let's go. Therefore, come on. We find that it is the reviewing authority. No, it is the recording authority for the ACR 2001 dash, no, don't say that, you just strike it up. Next, in paragraph 9 of the affidavit in opposition, it has been mentioned that in the ACR format, there is no column for grading of the ACR for the reporting authority. In this case in hand, as already stated herein before, the reporting public recording authority had given a remark of outstanding. First off, the secretary to the government of Assam, PWD department, by his note dated 5/6/2001, had stated that he had accepted, in inverted commas, accepted as proposed by the reporting officer as very good, inverted comma close. Full stop. The reporting officer, reporting of the recording officer, did not give a report of the grading of inverted commas very good to the petitioner. in column number bracket small k, it goes within bracket A, again within bracket 2, against the column designation, comma, the reporting of the recording authority has mentioned outstanding dash capable of handling multiple projects at a time. Next, the ACR for the year 2000-2001. Comma, the reviewing authority for the recording authority in column 1 within brackets A within bracket 2 of the ACR has made the same endorsement of similar endorsement of inverted commas, very efficient and capable, inverted comma closed. So however, the reviewing authority had graded the petition as outstanding however, the accepting authority had stated inverted commas accepted as very good, inverted comma closed. Full stop. Therefore, the endorsements of the superior authority is not found sustainable. Next paragraph. At this stage, the additional senior government advocate has submitted that the departmental promotion committee which is known as this inverted comma selection board, inverted comma closed, in its by its minutes dated 19/6/2002 had done the exercise of promotion, had undertaken the exercise of promotion. Please stop. From the said date till this writ petition was filed, on 22/9/2014, the petitioner was happy with his position. And in the meanwhile, he got 2 promotions to the post of Mrs. Dhawal.
To the post of executive engineer in 2007 and superintending engineer in 2016.
So by 16, sorry, minute. For one promotion, he got the next in 16.
Stop. How after after waiting for almost years, from the date of minutes of the meeting of the selection board, on the fag end of his career, the petitioner approached this court by filing the petition.
At that point of time, I was
Accordingly, it is submitted that the writ petition is liable to be dismissed on the ground of delay and laches. Next one. So we don't find the said ground to be fatal for the petitioner because in the writ petition he has projected that he had submitted two RTI applications dated 5/4/2014 and 10/4/2014, and in response to the same, he received RTI reply dated 3/5/2014 and 12/5/2014 respectively. In this case, the rule was issued by order dated 26/9/2014. The respondents did not take an preliminary issue of the writ petition being barred by limitation. As indicated above, this writ petition was filed on 22/9/2014, and the matter has come up for hearing a little less than 10 years after the institution. Therefore, at this stage, the court is not inclined to non-suit the petitioner on the ground of the writ petition being vitiated by delay and laches. Next paragraph. We are also unable to accept the submissions made by the learned additional senior government advocate that the reviewing or accepting authority had taken into consideration the entry made in the ACR for the year 2000-2001 and 2001-2002, and the grading of very good was awarded on the strength of entries made by the reporting of the recording authority. Stop. It is the stand of the respondents number 1 and 2 that the recording of the reporting authority could not have granted him the petitioner ranking of grading of excellent, outstanding. Even in such a situation, when the accepting authority is giving a remark of very good, following the ratio of the case of Devdutt within bracket Sutra and Sukhdev Singh within bracket Sutra, when they said communication ought to have been communicated to the petitioner. Stop. Accordingly, the court is of the considered opinion that the non-communication of the remark for very good entered in the ACR of the petitioner for the year 2000-2001, 2001-2002. Is not sustainable as it runs counter to the law laid down by the Supreme Court of India in the case of Sukhdev Singh with the Jagat Supra, as well as Devdutt with the Jagat Supra. In the present case in in the present case in hand, petitioner has been able to demonstrate that the breeding of very good that resulted in his earning of 3 marks in the minutes of the selection board held on 14/5/2003. Whereas on earning the remark of outstanding, the petitioner had earned 4 marks in the preceding ACR, which is elaborated herein before. So accordingly, the petitioner is found to have suffered prejudice from the non-communication of the remark of very good in the ACR for the year 2000-2001 and 2001-2002. Next paragraph. Resulting comma, the selection board, according it is held that the selection board could not have denied promotion to the petitioner by relying on the uncommunicated ACR having a grading of inverted commas very good. Stop. We also hold that had the petitioner been given an opportunity of timely communication of the remarks made in the ACR, he could have represented against the said remark. Full stop. The said opportunity was lost for the petitioner. Full stop. In the meanwhile, the petitioner has superannuated on 30/4/2020
As additional chief engineer, Lordship.
as additional chief engineer for PWD. PWD roads.
Building and national highway.
Okay, building and
National highway. National highway.
NH. Building and NH. Next paragraph. According to this, petition stands allowed with the following directions. Number 1, the concerned respondent authorities are directed to constitute a review DPC, public selection board, to consider the eligibility of the petitioner for promotion on and from which date your junior award promotion?
Lordship, that date would be 2009. Lordship, they were promoted on, my juniors were promoted
That.
Lordship, I'll
is
give the
finished
date.
or promoted. Number two. The said exercise of constituting review selection board for considering the case of the petitioner for promotion shall be completed within an outer period of how much? 3 months? Outer period of 3 months. And the date of service of certified copy of this order before the Secretary to the Government of Assam, PWD. Full stop. There should be no address to cost.
Lordship, if possible, Lordship may record that since he was working in charge, chief
My lord,
engineer.
no,
that
not a
is-
prayer,
that's
prayer,
not-
the expedition ballot.
That can't be.
That can't be done.
No, if he succeeds upon.
No, that can't be because you are in charge. In charge, you know what is the meaning of in charge. Especially in
know that,
PWD,
Lordship.
people will know.
But his juniors got promoted.
No, no.
Lordship.
My lord.
Full-time
there are
promotion
selection
and this
that
is.
is altogether different exercise.
Mr. Zahar has made out a point.
Lordship.
For 14 years, 12 years, you don't do anything.
No, I got promoted as executive engineer in 2007 itself, Lordship.
So therefore, you see, you see, delay and latches, we are not gone into that
Lordship.
since you have retired. Delay and latches, when you are promoted subsequently and you are accepted it, that operates against you.
2007
Because if
before
we-
promotion
if we
and
record that,
2014 he came.
then we'll disentitle you to that because once you allow your stand, because you see, there are umpteen numbers of judgments, including of this court, where it is stated that when the rights of others have fructified, then you can't be placed there. Because the right of the others have already been fructified. You'll have to be placed before someone. Because if you press that, then you'll have to recall the order because we can't give you that.
And
That
this
is gone. We cannot undo, my lord, certain things.
That due to their wrong only, Lordship. I
No,
have
no,
to
it's
suffer.
otherwise. It's 2007, you accepted it without any demur. Once that demur is not there, then because if you put that into the order, then we'll be perhaps referring to the other judgments, including of this court, and say that you have allowed others right to fructify.
Notional benefit at least, Lordship.
No. Notional benefit you will always get because he has given you the promotion that means.
That they may
notional
not consider because Lordship, that legal notice is pending since 2014, Lordship. And they did not do anything.
No, you take your
Lordship.
choice, because if we give that handle, because again then, since you have raised this issue, we can not also say that the promotion would be the end of the list, not, you will not jump over someone. In that grade, you will be lowest, placed lowest.
Yes, Lordship, that will also do because all my juniors got promoted in the
But that's
meantime.
okay, but
And the least.
that's why you're not recording that. Once we record that, then we'll have to take a call. You allowed others rights to fructify. Then we'll have to recall this order on the ground of delay and latches.
I was greatly deprived because of this, Lordship.
No, that's okay. You take your call. You still have a right to argue.
No,
But
Lordship. Just that
will-
observation, if entitled Lordship, he may be granted notional benefits. That much only I am asking.
No, if they consider you for promotion, that will be, it will get that. Do you need an order of that?
Lordship.
Once they consider you for promotion up to that grade, can they say that, no, we are promoting you, but without financial benefit? Can that be done?
That cannot be, Lordship.
Then-
But in Devdutt also, Lordship,
No,
that
no, you must have
person,
some faith on the state. They will not do that.
Lordship, in Devdutt also, that observation was there, Lordship.
They will always give.
Lordship.
I have not seen any promotion order where they don't give the financial benefit.
When there will be promotion ballot, it will automatically follow.
It automatically goes. You
If the
get the
rank
grade
ballot
pay
will
and
get it.
the salary for that.
With the
In
rank, it
2020
comes.
only retired, Lordship. That exercise,
okay.
I don't think they will carry, Lordship.
You get it. I have not seen the government acting like that.
Paragraph
To give
47 of,
promotion and not to give financial benefit.
paragraph 47 of
no.
Devdutt, Lordship, if
clearly
You were
specifies
sleeping.
that thing only,
You were
Lordship.
sleeping over your right. No. That observation not making. Other matters I may not take up. Mr. Chaudhary, huh? I'm not taking up any matters. Suddenly I'm having fever.
Oh, my lord.
So maybe day after tomorrow.
Lord, I have unlisted matter, my lord. I have unlisted matter.
Is it? Has it come? Just wait for some time. Let the court master take a call. Just wait for some time.
Look, here in this case, my lord, the petitioner is a nurse. In 2020.
Health, you'll have to get the studying order for health.
My lord, I think I will just look for him, my lord. Since my lord is already, once my lord is declared ready, my lord haven't taken up any matters left. I will just call my lord.
Yes, yes. Health.
Yes, my lord, he's there, man.
Hmm?
My lord, yes, he's coming.
Hmm.
My lord, he is a petitioner, is a nurse, my lord. In
No, that's
2000,
He's for finance.
No, Lordship, Mr. B. Gogoi, he's just on his way, Lordship.
yes.
Yes.
My lord, the petitioner, my lord, in 2023, transferred from Dibrugarh to my lord, the civil hospital, Gwalpara. And she was, my lord, she is looking after my lord ICU ward. Now, one of the colleague of my lord, that ward, who is a technician, my lord, harassing that nurses who are working in that ICU ward, my lord. Now, earlier, my lord, they have raised the
You were
complaint.
promoted when? We were posted when? What is the date of your posting?
My lord, my post in this place is 2023, my lord, that contained in page
3/3/23.
my lord, page 21, my lord.
Yes.
Now, my lord, afterward, my lord, since that one of the colleague harassing, therefore, my lord, we raised the issue before Deputy Commission, page 22, my lord. Here we have made a very specific allegation against the particular persons. On 1/5/2024, last month.
No, you see, there are two things. Number one, if you're saying that you are feeling insecure to do your duty, and on that ground, if they transfer you elsewhere, what is the wrong?
My lord,
It will be a
yes,
transfer
ma'am, quite
at
right,
own
ma'am, quite
request.
right. My lord, it is not a case, my lord, of singular person. Lord, see, page 22, see that 4 lady, my lord, staff nurse made their complaint. And as on today, my 16 nurses are working. Why I have been only selected, my lord? A timeline, kindly see, instead of taking action against that person, my lord, that blue-eyed boy, my lord, I have been transferred, my lord. And lordship, kindly see for a moment the reason which has been shown, which is otherwise interesting, that contained in page 26, my lord. Because I have approached before the Deputy Commissioner, raising complaint, therefore I have been asked, my lord, so question. You are hereby directed to explain why did you approach the Honorable District Commissioner Gwalpara regarding your allegation without prior intimation to your immediate controlling officer or to me. Further, you are also explain why one staff nurse, namely so-and-so, who is a signatory of your allegation letter, was asked to accompany you during my preliminary interrogation with you so-and-so. My lord, it is a matter of right, my lord. If somebody is not taking care of my complaint.
No. You have to show that you have gone to the internal complaint committee. Under the sexual harassment of women at
My lord,
workplace.
kindly see that the joint director is protecting that particular person. Earlier, we have
No.
formally
District
we have
Commissioner,
complained, my lord.
Mr. Samaria, you see, the district commissioner is not the authority for the hospital.
My lord.
Correct.
My lord,
He may be a member of the committee, a managing committee.
My lord, we have given copy, my lord. Kindly see, my lord, the copy we have given, lordship, that is page 25. The next complaint again we have raised on 9/5/2024.
No, this is to deputy commissioner.
Yes, downside, my lord, we have
No, copies you may give to 100%, including the prime minister. You have a right to do so. But
My lord, it is not-
the complaint is addressed to whom? It is not to the ICC.
My lord.
If it's a question of sexual harassment of women at workplace.
My lord.
Under the
Yes,
act.
Act is there.
You have authority to say, because
Quite right.
if you give a complaint to an authority who's an outsider,
My lord.
Definitely, they can take a plea that you are reporting it to outsider, you have not given us a complaint.
But anyway, my suppose if my approach is wrong, for a moment, take it in. That is suppose I have to approach before this authority instead of that. Understood. But lordship, reason is that, my lord, on my midterm stage, my lord, why I should be transferred from one place to another. I am, my lord, already suffering from medical causes, my lord. And lordship, kindly see, as on today also, I am, my lord, in a my lord, ICU because of this harassment, my lord. And question is that, my lord, midterm, my lord, there is a clear direction that without 3 years, my lord, a person should not be transferred, my lord, until there is administrative exigency or, my lord, public interest, my lord. There is not a single instance where it shows that, my lord, any cause remains there which goes to, my lord, favor the issue of, my lord, administrative region or, my lord, any public interest. The transfer which has been made, my lord, to a rural area, my lord, there is no ICU unit. I am assumed today working in ICU unit. There are 6 ICU beds are there, my lord. If I would be out, my lord, ultimately people would be sufferer, my lord. And why, my lord, this person has been protected, my lord? Question is that, my lord.
What is the difference between your Gwalpara and this Jaleshwar Hospital, Gwalpara?
My lord,
What
there
is
is
the
a
difference?
distance, my lord, of 60 kilometers, my lord. And this is a rural area, my lord, and there is no ICU ward there. I am, my lord, working since beginning in ICU ward, my lord. And there are 6 beds in Gwalpara, my lord. If I would be out, my lord, one even bed would be vacant, my lord. Now, lordship, 3 years policy is there, my lord. So their own government policy, my lord. I kindly see that woman is, my lord, this lady is, my lord, unmarried, my lord, lady is now being suffered of a particular person. The higher authority has to take care of that, my lord, seriously. Even my approach may be wrong or this or that side, my lord. A nurse is there, my lord. And what message will go to others, my lord? 16 nurses are working, my lord. It is a clear-cut case of punishment, my lord. And time limit, kindly see, my lord. On 1/5/2024, I raised the complaint, and immediately after one, my lord, 10/5/6/2024, transfer order has been issued.
Okay. Yes, Mr. Gogoi.
Well, first of all, my lord, from the impugn order, it appears, my lord, she has been transferred in the same district as lordship has already raised the query. Secondly, my lord, from the order, it appears, my lord, she has been transferred pursuant to one letter dated, my lord, 5/6/2024 of the Director of Health Services Assam, not by the Joint Director at his own will. But you will see, my lord, in pursuant of the order dated 5/6/2024 of the
Which
Director.
page?
Page, my lord, 37. Type copy is the 36.
No, 36,
37, my lord, 37.
36 is the order, my lord, impugn order. That is a follow-up action. 37 is a follow-up action. Midterm transfer this way, my lord, is absolutely impermissible, my lord. Clear-cut case of, my lord, punishment, my lord.
36 is the, my lord, letter dated 5/6/2024. It has been issued by the Director.
My lord, if I remain there, my lord, nothing will happen, my lord, wrong to the, my lord. My lord, there are 100 posts, my lord, for nurses. Agent today, 16 nurses are working. There is already a, my lord, a crisis there, my lord. And ICU, my lord, unit, especially, my suffering from, my lord, nurses, my lord, attendance, my lord.
That part the authorities will look
Understood,
into.
but
Said in
I'm
the
just
approval,
making,
don't worry about it.
No, but Mr. Shahriar,
my lord,
there are two things. Number one, you allege harassment.
my lord.
And therefore, if you are transferred out.
Yes. Let them substantiate, my lord. Let them place the
And
records,
the
my lord.
second is that on issues of transfer,
My lord.
there's a well settled law that you have to first join and then agitate.
Yes, then submit a representation before the authority.
My lord, kindly see, lordship, there is a clear-cut, my lord, instruction. My lord, their own government, that 3 years, my lord, is the term. If middle term, my lord, if suppose somebody inclined to transfer, my lord, there must be a valid reasons, my lord. Now, here is a case, my lord, it is prima facie circumstantial evidences shows, my lord, that because I have raised certain allegation against my colleague, my lord, this.
You're raising it to outsiders.
Understood, my lord.
Deputy
Anyway, my lord,
Deputy
let us
Commissioner is
take,
not the authority.
let us take the allegations apart from for a moment, my lord. Then why, my lord, midterm transfer, my lord? And there are 16 nurses are working. Why I have been selected, my lord, individually, my lord.
Let him say, Mr. Gogoi.
My lord, here I pray, my lord, she will take up on, my lord, Friday or Monday. I can place the instruction, my lord, why, my lord, she has been transferred out.
Yes, my lord.
From the civil hospital. But, my lord, let her join to her, my lord. Since, my lord, it relates to health, my lord, she must join in her new place of posting, which is within the district. Lord, she will definitely examine on that day regarding the, my lord, interim prayer, my lord. Because the order was issued on my lord 6/10/6. And on 6/6, she went on my lord leave,
Medically.
medical leave.
Tomorrow will over.
You'll have to join them.
But my lord, I think perhaps tomorrow
Since
also.
it is within the same district.
Yeah, lots of judgment,
What
my lord,
is-
clearly says 3 years,
what
my
is
lord. If suppose there is a situation which has to be maintained, there must be exceptional case, my lord. And why, my lord? I have been, my lord. I have given one judgment also, my lord. Last page. Okay. Huh? 69930 312
312.
3129.
Which paragraph of this judgment?
My lord, I have referred, my lord, judgment, lordship, that is our on Guwahati High Court. Paragraph 27, my lord. This is, my lord, 2007 for GLT 712. Paragraph 27, my lord, prior to date 26 is there, there is a reference of one case, Jyoti Kumar Das. Paragraph 4, records further revealed that transfer was ordered primarily on consideration of certain complaint lodged by some political person, members of the public against the writ petitioner, if the petitioner has been indulging in any conduct not befitting the office of the CPDO contrary to the public interest, the respondent should have to go for any inquiry for inquiry imposing some penalty as may be permissible under the rules. Premature transfer at the behest of the members of the public without any inquiry is against public interest. It tends to destroy the moral of the government servant. Such a transfer cannot get the seal of approval from the court, and the application for vacating order of stay is rejected. Paragraph 27. The above decision make it amply clear that an order of transfer of employee cannot be made without valid reason. In such a view of the matter, I have no hesitation to answer the question raised by the learned counsel for the respondent in the affirmative and to say that an order of transfer, even though in the nature of administrative order, must be supported by valid reasons. And here's a case where 60 nurses are working agent today. I have been chosen, my lord, because I raised the voice, my lord. And what message will go, my lord? Can you see? Agent today, my lord, can you that this may be stayed, my lord. Let them come with instruction, my lord. And nothing will happen wrong, my lord. The ICU ward demands, my lord. And see my condition as they give me such a situation, I am nowhere, my lord. Because of his medical grounds also, my lord.
SCC you have, no? SCC, just take out 2003, 11 SCC 740. Basil, keep on table. Oh. You take this, give this to him.
Today, my lord.
This is that observation in paragraph 26 of this judgment.
My lord.
Shillong bench.
Yes, sir.
This is Sarvesh Kumar Avasthi.
Yes.
Now look at this order. It doesn't say any guideline. Look at this order. It's only 4 paragraphs.
Yes, my lord.
Doesn't lay down any law.
My lord, this judgment was pronounced 2007, and I have given the, my lord, guidelines 2009, my lord. I have.
In this judgment, the learned single judge has relied on Sarvesh Kumar Avasthi.
Yes, ma'am.
Sarvesh Kumar Avasthi, I have opened up for you.
Yes, ma'am.
Sarvesh Kumar Avasthi is only an interim direction, and the Supreme Court says that you list on so and so.
Yes,
So therefore, where is the law laid down?
yes,
Because KL Abbas, SL Abbas has not been overruled.
quite right, my lord.
SL Abbas says that you have to join first
No,
and then only challenge it.
My lord,
The
no doubt.
challenge would be maintainable,
My lord.
no doubt about it, because, and there is another judgment, I'm not finding it readily.
No problem, my lord.
It says that the guidelines is merely a guideline.
Yes, yes, no
And,
doubt, my lord. But
and,
lordship, lordship, one aspect may kindly be considered that kindly the timeline that which has been maintained. It is a case where my lord clearly indicates, my lord, because of certain situation, now they make me to my lord shift from one to another place. Question is that, my lord, there are other, my lord, their colleagues are also there. Then what message it will go, my lord? If it is a normal transfer, I have nothing to say, my lord. And here, my lord, clearly a case of, my lord, that just to give a message that if somebody raise voice, then they have to face the, my lord, punishment by way of transfer, my lord. And question is that, my lord, if suppose I would be, my lord, remain there, my lord, it will not affect anything. I'm sincerely discharging my duty in ICU ward, my lord. And there are 6 wards, my lord, 6 beds are there. If I would be out, my lord, one bed become vacant, my lord. Therefore, little bit public interest also survive if I would be there, my lord. But if I would go to new place, there is no ICU unit, my lord. I just become a normal nurse there. At that moment, my lord, let them come with instruction. Till that, my lord, kindly kept in abeyance, my lord, this order, my lord. That is my humble prayer, my lord. No wrong will be caused, my lord. But if I will be transferred, my lord, it become very difficult for me. Prima facie, my lord, shows that it violates the 3 years terms, my lord. The medical ground is also, my lord, there, my lord. I'm taking treatment, my lord, at Gwalpara, my lord. I will not get treatment from that, my lord, place. For the 9, my lord, office memorandum policies for transfer of government officers clearly says, my lord. But ultimately, he will be succeed, my lord, against whom, my lord, I have raised voice, my lord. This is my, because of this situation, my lord, as on today, I am suffering, my lord. And my treatment is going on, my lord. This is latest, my lord, 15/6/2024 medical document. And page number 4, my lord, ICU ward where I am, as on today, my lord, taking treatment.
Painkiller zero no member.
It's a small, my lord, employee, my lord. Nothing will happen, my lord, if she will be remain, my lord. At least she can take treatment, my lord. That is, my lord, good cause, my lord.
Yes, Google.
My lord,
Don't transfer him.
till Monday, my lord.
For 2 days.
Yes,
Don't
I can
transfer.
place it on Friday, my lord, whatever record is there in this regard. And lordship will say it's status quo, my lord, in this regard.
First, may kindly fix it Monday, my lord, if possible.
So at least I can place it before his honorable court, at least the
Okay.
grounds, my lord.
Heard. Mr. S. Chamarian, counsel for the petitioner, as well as Mr. B. Govind, and standing counsel for the health department. Next. As the transfer of the petitioner has been received in this litigation, the learned standing counsel for the health department has submitted that as the petitioner is a staff nurse, he would make an endeavor to produce the instructions on
Friday, my lord.
24, no, on 21,
21.
6, 2024. Next, list on 24, 6, 2024. Let's go. Without examining the case of the petitioner on merit, as an interim measure until the next returnable date, and pending issuance of notice on the respondents, till 24/6/2024. The status quo with regard to the petition shall be maintained by the respondent authorities. Because you see, the reason for doing so much of thinking is that you are working in an ICU, and in ICU, all three wings are of equal importance. So one is the doctor, second is a technician, and you're the staff nurse. Three people have to work in tandem. If you don't have a good relationship between all three of you, then somebody has to go. It's not a question of whether you are violating the office memorandum. If three people don't work together, somebody has to go, even if it is a violation of your right under the OM.
But if suppose one gentleman harassing numbers of nurses,
No,
he should
but
go.
somebody has to go.
Yes,
We can't have that situation
Yes,
in an
no, no.
ICU. Correct.
let them place, my lord. What is
And insofar as your condition is concerned, with BP of 100/80, I can give you a guarantee. If you look at my BP right now, my BP will not exceed that. I am a perennially low blood pressure person since my childhood. I would have low blood pressure. Number two, just now, my doctor came and checked me up when I'm not feeling well. The palpitation was 118. 72 is the normal limit. Mine is 118. That's normal for me. If I do an exercise, my palpitation may go up to 170 and 80.
Oh.
Therefore, I monitor myself when I'm doing exercise. I have to do it. If I run, my palpitation will go up to 170 plus. But this is a condition I'm having since my, oh, this is that. Only 4 paragraph, doesn't, they don't allow.
Yes, my lord. I will check.
So based on this, when the matter is pending, you see last paragraph,
Madam.
under the same as Chief Secretary, UP.
Fourth paragraph.
File necessary affidavit.
Yes, sir.
So this is not an order which can be relied upon and then
Yes, madam.
without discussing SL Abbas. Even a coordinated bench would not have done it.
My lord, today I have got one another, my lord, notification could not be collected. I have just gone through. Personal department issued that notification. Where it says my inside the district, if any transfer to be taken place, my lord, grade 3, grade 4, including medical staff, then deputy commissioner competent person to issue transfer order.
Yes.
I will bring it, my lord.
No, we have
Certain
it.
situation he may be,
yes,
but it's not that,
just-
here director has given the approval.
It is for the departments.
Yeah.
Well, here in medical, it's a joint director of health service, it's a
No,
authorized
my lord.
department.
That notification also, my lord, certain role to play.
But deputy commissioner would not be an authority in the case
Yes,
of
my lord,
health.
quite right, my lord. On Monday, my lord.
This,
On Friday.
Monday.
So this
he's wanting on Monday.
Monday.
He's having some difficulty of that.
So
I'm sorry to all of you for not being able to take up the matters.
My lord, item 14 may kindly be fixed. Here you
Let the
Old
professor take a call. We'll have Mr. Chaudhary's matter because he's coming from auto station.
21.
21. Day after tomorrow. With this matter. Mr. Paul's case, you just see if it can be done.
Item 14.
Mr. Paul, we examine your case. We don't say anything right now.
The weather is very bad.
Pardon me?
Weather is very bad. I also have very bad cough.
Huh?
Weather is very bad. Weather.
Weather is bad. No, not because of that. I don't know why, what happened. Yesterday night, I was feeling discomfort. I came here, but I have no discomfort.
Your lordship should take some rest also.
Huh?
Your lordship should.
Rest is something we don't have. There's a meeting at 4:45. So rest is something we come only with retirement. All this old contacts, we can renew only after a debit office. Very difficult position at times. The reason is that we can't even interact with outsiders.
That is.
And then I realized all my staff, they all say, now we realize why we have this name of warrant of appointment. Because once you get this warrant, then you are under police custody for
Warrant of
entire
confinement.
service life. You don't have any independence. This is a part of our life. How is everything?
Everything's fine.
Your daughter?
My daughter's fine.
She's okay. We'll examine, let him examine. If we are not saying anything.